is Jamilya. I'm excited to present legal issues of decentralized dispute resolution platforms and their compatibility with international regulatory framework. So, in order to understand the role of blockchain-based mechanisms in the dispute settlement, I think it would be quite important to provide an overview of alternative dispute resolution methods. And alternative dispute resolution methods, they refer to means that basically form of means that are targeted to resolving disputes outside of courts or federal judicial system. And to quote Professor Susan Blake, a sound and just court system is undoubtedly a primary choice for dispute resolution, but no system is perfect. And still, there are various ways in which a good court system may still fail to meet the needs of individual litigants. And the following factors are believed to be the most important ones that influence one's decision to opt for alternative dispute resolution. And some of them were mentioned by Federico. So it's extended time dictated by civil procedures, expenses, of course, that are associated with legal representation, and confidentiality, and frequent focus on past factual scenarios in courts that exclude an opportunity to cover a wider range of matters. So, as it has been mentioned before, the most famous ADR methods are mediation, arbitration, negotiation, etc. And online dispute resolution method, I think, is the most interesting for us because it presents methods or tools that allow technological capabilities to be directed at the challenge of responding to disputes. And academics such as Ethan Cash and Ordner Rapinovicini, they have done great work of researching and exploring different ways of ADR, how they can help in assessing certain problems with dispute resolution. And we have eBay marketplace example, for instance, that I think would be familiar to many, that provided this first example of online dispute resolution method that enabled two parties to be able to set, especially when it came to small disputes, and that needed some very quick, efficient way of settling disputes online. Although decentralized dispute resolution systems or blockchain, it can be seen as an evolved version of online dispute resolution. And for that, the reason for that is that decentralized dispute resolution methods, they can handle not just small case, but small claim e-commerce cases, but bigger and wider range of cases. And when we talk about online dispute resolution, we still have certain problems that are associated with being able to participate anonymously, or problems of centralization, and etc. So I would like to take your attention and have a look at the World of Access to Justice World Justice Project that has a Rule of Law Index. And I came across this project when I talked to a senior colleague of mine, Dr. Robert Hung. He's a Venezuelan lawyer. He also an academic that explores different ways of how blockchain technology could solve certain social issues. And I think when in general we speak about social issues, blockchain, and use blockchain for public good, we refer to the ideas that blockchain protocols might be seen as possible solution to tackle certain problems such as just access to justice. So going back to the Rule of Law Index, you would see that the World Justice Project gathers information from different countries and compiles it. So you would see that the green countries are the ones that are doing the best in terms of access to justice. And then you would see yellow, orange, and red countries, and Venezuela is being at the very bottom of the list, meaning that this is the country that faces problems of access to justice the most currently. So for now, I have to give my remark that I believe that there is no single protocol or blockchain-based dispute resolution method that could be just used single-handedly to solve problems such as access to justice. However, it could be seen as a tool that rather than discussing that blockchain-based mechanisms could be seen as a replacement of traditional dispute or traditional litigation, they could be seen as a viable alternative as part of ADR, or they could also be utilized in countries such as Venezuela, where unfortunately citizens don't have access to reliable judicial system. When we talk about compliance with international framework, and especially when it comes to recognition of Kleros awards, very often we refer to the Convention on Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention. And the New York Convention, as we know it, provides umbrella definitions for a variety of ADRs, and it sets harmonized rules that govern ADR out-of-court techniques. And as we know it, the convention was set and created in 1958, and the text itself, I'm sure our participants are quite familiar that it's not exhaustive at all. It's quite short, and therefore we have many guidelines, and then we have local courts who also pose additional requirements for the recognition of foreign arbitral awards. And with being said that, we know the examples where certain clauses are being interpreted slightly differently, and then we have a great work by legal scholar John Paulson that explored how different semantics of different words such as may, shall, must, especially when it comes to translation, they might present different degree of certain statement. And I think all of that covers that New York Convention, given that it was created in 1958, it does not, of course, include use of the internet or let alone blockchain technology. Although many practitioners discuss whether Kleros can be seen as compliant with it. And I think there is no straight answer to that question, and I'm more inclined to say no than yes, and I'm going to explain in a bit why. So first of all, we know that the applicability of the convention governs the recognition of foreign arbitral awards. And when we talk about Kleros, we don't have a jurisdiction per se. So for instance, the clauses that govern certain requirement to comply with local jurisdiction, in that sense, Kleros might not be seen compliant. Different articles, for instance, Article 2 sets the requirements for the arbitral award to be in writing. Then we also have Article 5, for instance, that, as I said, requires the arbitral award to be compliant with the law of the country where the arbitration took place. So there are certain straightforward clauses that Kleros does not comply with, to be fair, because there's no jurisdiction. As I said, there's no there's no arbitral award that would be signed by arbitrators. So there is an award, there isn't a decision that is reached by jurors, but the arbitrators, they act anonymously. They do not sign, and let alone they do not provide the signed copy to the parties. Also, when we talk about the arbitration rules, international framework, we cannot not mention unilateral arbitration rules. And I think it's also very important that many jurisdictions have shaped their domestic regulation arbitration around the 1985 unilateral model law on international commercial arbitration. And the document contains the most of the international consensus about the arbitral rules, and many of them, of course, establish form and contents that an arbitral award should have. And although we do have instances where local courts, we have many French precedents where it didn't comply with most common interpretation with New York Convention, for instance, and that enforced arbitral awards that were set aside by home state courts. Although this does not doesn't mean that Kleros' lack of jurisdiction or lack of compliance when it comes to providing certain information about arbitrators, so it doesn't make it compliant with those rules. And I would like to talk about the theoretical approach that has been developing around decentralized legal framework. Unfortunately, I don't have much time to stop on each document, but here on the slide you would see white paper presented by Wesley Thays in 2018, and it provides a theoretical approach that tries to merge international enforcement framework with decentralized legal framework. That is quite interesting, and I think for those who might be interested, I would suggest taking a look at this white paper, and you would see on the slides the link to the source. And then another theoretical framework that is being prepared and shaped right now, and I'm pretty sure many of you might be familiar with that, and my colleagues have given introduction and overview yesterday, if I'm not mistaken, about Kuala DAO model law. And this document covers governance of DAOs, although it provides certain definitions, which is very important. And one of the definitions that we can see in the slide is definition for dispute resolution mechanism. And that is just the examples of recent theoretical developments that are being done by practitioners, academics, legal scholars. So another thing that I think would be quite worth mentioning is the so-called Mexican case. And the Mexican case became quite popular, and this is the case that took place in Mexico. And it was a case between two parties. They had a very simple lease agreement. One thing, although, was quite unique, because one of the things in the agreement was that the parties mentioned that in case they had disputes, they would use Kleros as an arbitration tool. And they were quite successful in terms of they had a third-party arbitrator who took all of the evidence and submitted it to the Kleros court. And Kleros jurors examined the evidence and rendered the decision. Later, the decision was taken to the local Mexican court and was, in fact, enforced. So many people were starting to say that that was the first precedent that recognized Kleros as a foreign arbitral award and as a viable mean of arbitration tool. And we can't say that quite yet, because we had the situation where two of the parties didn't question the validity or legality of this arbitral award, and they were quite happy with the decision that Kleros rendered. They didn't oppose it. So we don't know what would have happened if one of the parties started to question it. So in that particular case, the court has rendered that it didn't mind to the parties' contractual agreements to use Kleros as an arbitration tool, and rendered the decision for one of the parties to comply with the decision that was rendered by Kleros within 5 days, if I'm not mistaken. So this was covered, and if you are interested, I would suggest you to take a look by Mario Viras that you see on the screen. He is a Mexican lawyer and also ex-fellow in Kleros that has a fellowship of Kleros. So although we cannot just define whether it was recognition or whether it was just merely Kleros, Mexican court's acceptance of that clause that party chose Kleros to use as a dispute resolution method, but it sets very important precedent that national courts start to see parties using alternative dispute resolution methods such as Kleros that enables blockchain dispute resolution. So I think it also would be very important to talk about trends that are happening right now in different jurisdictions. And one of the examples of states' eagerness to shift towards the implementation of decentralized technology would be the United Kingdom. And in 2021, the UK Jurisdiction Task Force, chaired by Sir Geoffrey Ross, has introduced the digital dispute resolution rules that are designed to enable faster and more more cost-effective resolution to legal disputes. And I think that is quite a great trend that we see, and also that was followed by the previously published legal statement on crypto assets and smart contracts by UK Jurisdiction Task Force in 2019, and following smart legal contracts advice to the government by the Law Commission in 2021. So we can say that those documents lay foundation for the perception of smart contracts technology in the future and current compatibility of traditional common law systems, because the response that we see from UK jurisdiction, for instance, from UK Jurisdiction Task Force, they say that English law system is quite flexible enough and is ready to facilitate decentralized dispute resolution mechanisms as well. Just another examples from different jurisdictions. You could see Illinois General Assembly Public Act, and also Council of the European Union. And Council of the European Union in 2020 issued series of conclusions that emphasized the use of digital technologies that can also improve access out of courts and tribunal alternative methods to dispute resolution. And I think that's just quite important if we are to evaluate and analyze the current trends that we see happening in different jurisdictions. So to summarize my presentation, I would like to say that Kleros decentralized dispute resolution platforms or any other similar decentralized dispute resolution mechanisms can be seen as a viable alternative dispute resolution method. So rather than just saying that it's a tool that would replace some judicial system, I think it will be quite more productive to think how we can merge, first of all, the use of decentralized dispute resolution mechanisms and the existing frameworks. So just one thing that is also very important to mention is that most of the users that use Kleros, for instance, they sometimes don't even need that recognition in the courts, and that is explained by the smart contract technology. So most of the disputes that we have now in Kleros are happening on chain, or as I call them, happening organically, and they might involve funds that are locked in escrow service. So once the decision is reached by the jury, the smart contract enables automated self-execution of this decision. So we don't need this additional enforcement from the state. Although we have many different instances, as we've seen with the Mexican case, where parties might have additional relationship that are not set on chain. Let's say there are lease agreement and not just questions that concern reimbursement of the party, but also, for instance, the need to vacate the premise, and that is something that cannot be enforced on chain. So we need this regulatory framework that would be flexible enough to accept parties' choice to choose decentralized dispute resolution mechanisms. Just one more thing that I would like to add. I think saying that Kleros or any other decentralized dispute resolution tool is fully compliant with any frameworks or local regulation is just not right, because there's so many different local regulations or arbitration rules that might explicitly say that it wouldn't be possible to choose Kleros or, for that matter, any other alternative dispute resolution tool. But also saying that it's non-compliant with anything, therefore it's not a viable mean, it also wouldn't be fully correct, because we see the shift that many jurisdictions are quite flexible, and hopefully in the future we would see more precedents and we would be able to judge on the state of decentralized dispute resolution mechanisms in the scope, and we would see emergence of different protocols, not just Kleros, but similar protocols that would offer efficient and reliable means of dispute resolution. I'm going to finish here. I'm so sorry I don't have much time to go into details, although I'm very open for collaboration and feedback and we'll be very happy to continue this discussion and answer some of the questions you might have. Thank you.